You lured them out of the house using one of your many labyrinths of lies. They went to the mall and movie at your request, thinking you'd be discussing divorce details with your victim. And you didn't even allow them to say their customary goodbye to their father before you murdered him. Now they live with not only the murder of their father at the hands of their mother, but the fact that had you not convinced them to leave, you may not have had your window, or at least on that date, to commit your heinous acts. Their testimony was clearly difficult, but it was compelling. Your sons displayed on the stand the courage and strength of character often associated with those who have endured significant trauma. I use the word sons loosely, as they clearly do not recognize you as their mother anymore. Suffice it to say that if there was ever a list of all of the things parents should do on behalf of their children, murdering the other parent would not be on that list. This court is to balance punishment, protection, deterrence, and rehabilitation where possible. I'm hopeful you will engage in programming when returned to the Department of Corrections, programming which may or may not provide some measure of rehabilitation, but only a sentence of life without the possibility of parole can protect others from you and deter others from committing like conduct. And only a sentence of life without the possibility of parole can properly punish you for the heinous acts you've committed in burning your husband alive and in leaving your children with that imprint forever. The sentence of the court is life without the possibility of parole. Credit is 3,367 days. I'm showing that mandatory financials have already been paid, so I won't reorder those. And counsel, the judgment will this time state one first-degree murder conviction with the two alternative theories. Is that satisfactory to counsel?
Yes.
Peggy's like, which one?
I'll just put first degree and then put under two alternative theories, either felony murder or premeditated. Does that work? Okay. Ms. Sturmer, you have a right to appeal the conviction and sentence. You have a right to ask for a court-appointed attorney to assist you in that appeal if you're financially unable to afford your own. If you do wish to make the request, you need to fill out the paperwork we're getting you now and turn it back into the court within 42 days of today's date. Bond is canceled. Anything else, counsel?
Nothing